Hello, my name is Robert Goodwin, and welcome to Law on the Line. I would like to welcome my guest for today's episode, and that is John Paone III, correct? And you are an associate with your dad's firm, Paone, Zaleski, and Murphy, and two offices, one in Woodbridge and the other
Red Bank.
And John is a family law specialist and a graduate from Thomas Cooley Law School, and he graduated a number of years ago now, 2012, and he's the former law clerk of two Middlesex County judges, retired Judge Berman and Ann McCormick, who I believe is retired now?
She is retired as well.
She's retired as well. And John, in his first employment, worked as an attorney general for the state of New Jersey, as a prosecutor for the attorney general's office. Is that correct?
That's correct.
Anyway, today's conversation is going to be about juvenile proceedings, and John is going to give us the benefit of his experience and expertise and provide us with a timeline, so to speak, with regard to juvenile delinquency law in the state of New Jersey in our Superior Court. So welcome aboard, and let's get to work because we have a lot of questions.
Absolutely, Bob. Looking forward to it.
All right, good. So the first thing, John, what is the definition in this state of the legal term juvenile delinquency?
To put it simply, it's any child under the age of 18 that commits an offense. That is what a juvenile delinquent is. And when we talk about an offense, we could talk about a number of different types of offenses. There are certain crimes that are called indictable offenses that are typically heard in the Superior Court. There's also disorderly persons offenses, which are less severe matters that come before a court, usually punishable up to 6 months of New Jersey State Prison. However, most of these cases fall under the purview of the family court system, where you go before a judge who then adjudicates the issue to determine whether or not a minor, in fact, is a delinquent.
So it's really an adjudication and not an ultimate determination of guilt. Is that correct?
That's correct.
And you mentioned disorderly persons offenses. As a former prosecutor, for the municipal prosecutor, disorderly persons offenses are generally heard in municipal court. Are juvenile cases heard in municipal court at any time?
Most of the juvenile cases are going to be heard in family court. It's really only the small exception of cases where you're dealing with more lower level minor offenses like the disorderly persons or even petty disorderly persons, which is below that. But usually that falls within the purview of the family judge in terms of hearing all different types of juvenile matters.
Now, you asked an interesting question here, and it is, do charges need to be brought in every instance where a juvenile commits an offense?
They do not, Bob, and let me explain to you why. So one of the underlying goals in terms of dealing with a juvenile when there's the potential of law breaking is we're trying to rehabilitate the young person. We're trying to make sure that they receive important services in the community. There are two different ways that we can address a smaller offense by a juvenile without taking it through the court system. One is known as a curbside warning. This is where a police officer may approach the juvenile and let them know, listen, I'm going to give you a pass, but if you do this again, there will be consequences and you will have to go before the court. There's also a situation that's known as a station house adjustment, where there may be a complaint that's filed with the court. We'll talk about that momentarily. But the juvenile, as well as the parents or guardian, go to the police station to meet with the officer to address the issues. And it's at that point that there's a determination made as to whether or not a complaint will actually be filed, or whether there can be adjustments that are made, whether you dismiss the complaint and there's parental involvement, whether there's curfews or the child may be grounded for a period of time. So there's ways of dealing with these issues outside the court system that I think it's important for your viewers to know.
And how quick or how soon after the offense is an adjustment at the station house?
It could be made within a period of even a few hours. A lot of it depends on the circumstances in which the juvenile is found to be committing an act or alleged act of delinquency, where the police officer may approach the juvenile that same day. A curbside warning, that could be done without parental supervision or involvement. A station house adjustment, perhaps that's within a day or two after that they go to the police station or barracks to report to the officer and to discuss what happened.
And fortunately, that's a good outcome for the juvenile.
Absolutely, because there's really a presumption against incarceration or detention. Again, we'll speak about that as we move forward. But the point is to try to improve the juvenile situation and make sure they can conform their behavior with the law.
As somebody said, the courts want to help the juvenile learn how to avoid getting into trouble again. And that's a good goal. Now, how are charges against the juvenile filed in New Jersey?
So typically, your first step is there's going to be a formal complaint that is filed with the family courts. And the way that's done is typically the law enforcement officer who has personal knowledge is going to sign that complaint, is going to include within that complaint the allegations or the charges against the juvenile. They're going to reference the name of the juvenile as well as the date of birth and any other relevant information that's going to be important to addressing that case.
Now, when is the juvenile or the parent of the juvenile, along with the juvenile, presented with a copy of that complaint?
They're going to be presented with a copy of that complaint upon it being filed through the court system. So they're going to get a notice from the courthouse with regard to whether or not it's a complaint summons. If it's not a complaint summons, then typically you're going to have a hearing at the courthouse because there was some arrest or detention that was made. A lot of it comes down to whether or not the act itself is so egregious that it requires the juvenile to be detained for a period of time.
And that happens based upon the seriousness of the offense.
Yes.
And the less serious the offense, and then it would be on a complaint summons and with a notice to appear.
Yes, absolutely. And I think it's important to know as well is that there's a vetting process that goes on, both from the standpoint of the prosecutor's office as well as the court system. What do I mean by that? The prosecutor's office is not going to follow through with a complaint unless they know, number one, that they've got the evidence in order to move their case forward, and two, whether or not it's a case worth taking to the court system, through the court system. The other aspect of this is with the court intake services. There are certain diversionary programs in which a formal court appearance may be avoided and that a outcome other than detention may result for the juvenile.
Okay, good. So one of the other questions that you've asked out of many, what does the legal process in court look like once charges are formally brought against the juvenile? So now we have formal charges, and what happens after those formal charges are brought?
So you're going to be on two different tracks. One is those juveniles who have not been arrested, who have been served with a complaint summons. They're going to get a notice from the court indicating that they have to return to court for an appearance. Whether or not they're going to need to have counsel or not is going to depend on the gravity of that offense. If it's a lower level offense, they're going to get a notice from the court saying that counsel is not required to appear on that juvenile's behalf. They can go to the court with a parent or guardian in order to kind of work out a resolution to the case. If it's
and that resolution would be before whom at that point in time?
That resolution could occur through a diversionary program where you're meeting with either a juvenile referee, or you're going through a process known as an intake services conference or a judicial conference where you're meeting with a court staff or probation officer, and a recommendation will then be made to the judge as to whether or not the potential sentence is appropriate. And that sentence could be probation, it could be community service, it could be a fine, it could be restitution if there's property damage, any number of recommendations that could be made to the judge. And the judge would ultimately have to adopt and enter an order to that effect. And
are there referrals to mental health services as part of that? Is that something that is commonplace in juvenile court?
Yes, there are certainly inpatient, outpatient options for a juvenile. I think a lot of it depends on what the juvenile needs in order to improve themselves, build upon their needs. Some of it could be substance abuse issues. Some of it could be mental health. Any number of different issues.
So in this informal process, and the parents and the juvenile are present, under any circumstance, may a juvenile appear alone?
Juvenile should not appear alone. A juvenile should have a parent or a guardian accompanied with them, because their knowledge and understanding as to the relevant terms in their case really needs to be with somebody who is with them, who can understand. A parent and a guardian are responsible for a minor, a child that's under the age of 18.
So at that point, when there is a recommendation through this deferral process, does the juvenile see the judge that same day for a determination of what the appropriate disposition is?
They can see the judge that same day. A lot of it depends on what the court's calendar is. If not, then they're likely to be renoticed for a new date to appear, but it's usually done within a very short time frame.
And that, again, would be for the judge to approve the recommendation and then to dispose of it according to the recommendation.
That's correct. And as I mentioned, the emphasis is on getting the juvenile back out into the community so that they can utilize the services that are important to them in order to improve their physical, mental, emotional well-being, as well as getting them on the right track.
Good. So let's advance the matter based upon the seriousness of the charge. So it's a more serious charge. It's an assault. If it were an adult offense, an aggravated assault, which would be a second-degree crime. And that could impose a jail sentence, period of incarceration between 5 and 10 years as a second-degree crime. So let's assume that in the juvenile scenario, and now we have a serious aggravated assault, and what is the procedure like in that instance?
In cases where you're dealing with a juvenile who must be detained for a period of time, the courts handle this in a very short time frame.
So who makes the original determination to detain?
The detaining would happen by law enforcement of the prosecutor's office based on a finding of probable cause. At the point of the juvenile being detained, there was going to be an initial appearance through the courts within a span of about 24 hours.
With the juvenile?
With the juvenile. The juvenile is going to be required to have counsel with him or her.
At that first appearance?
At the first appearance.
Now, that's pretty quick turnaround, and I know, and let's talk a little bit about the public defender and perhaps, and then maybe ultimately retaining private counsel. But how does it work where you get an attorney in 24 hours?
So there are legal services that are available through the New Jersey court system. You would contact them. They would put somebody in place to represent them at that initial appearance.
Now, who would you say they would contact them? Who's they at that point?
The parents or the guardian of the juvenile would contact New Jersey legal assistance to provide them with a host of options to have a public defender represent them. There's also the option of contacting the court through the ombudsman. They can provide them with the contact information so that they can get in touch with legal services who can represent them. But this is only the initial appearance. After that, there may be the option, if the juvenile and the parents want, to have separate private counsel represent them, as that will not be the only appearance in their court case.
And to have the Office of the Public Defender represent you, you have to meet certain income eligibility requirements.
That's correct.
So, I mean, that's, again, a quick turnaround. Are there public defenders working in the courthouse who are there every day that have a list of cases that are coming in from the detention center for juveniles, or our system doesn't work like that?
I think with regard to that, Bob, is they get these lists with regard to cases in which there are either emergent or important matters pending. And through their office, they then assign counsel. And a lot of it is subject to the scheduling and availability of the public defender through the Office of the Public Defender and what arrangements can be made.
Yeah, because I could see it being a practical impossibility for a family who may not know the court system at all to get an attorney that quickly. Now, are there judges who specialize or handle juvenile matters only at our courthouse in Middlesex County, which is where the show is being done, but throughout the state? How does that work?
In Middlesex County, specifically, Judge Venezia handles most, if not all, of the juvenile cases that come before her. It's going to vary county to county based on the judge's scheduling and availability.
And population, I guess.
And population, absolutely. I don't know offhand the number of juvenile cases in Middlesex County compared to the other counties statewide. But at least as far as Middlesex County is concerned, most of those cases are coming through the court system before Judge Venezia, who is the presiding judge in the family part.
And is that including an adjudication hearing or a trial, if you will? She handles those as well.
Correct. The adjudicatory hearing as well as the disposition, which is otherwise known as the sentencing process.
Okay. So now what happens, first appearance, sort of like an arraignment if this were adult court, and you're with the public defender or private attorney, that first appearance, parents are there. Is that a mandatory appearance for counsel at that first appearance?
If there is an arrest made and the juvenile is detained, it will be counsel mandatory and they have to be present. Following that initial appearance, though, within 48 hours, there's going to be a detention hearing.
Let's explain that. What does that mean?
Absolutely. Essentially, it's the equivalent of what would be known as a probable cause hearing, where the prosecutor has the burden to show that there is sufficient evidence which warrants the juvenile to be detained for a period of time. What does the prosecutor need to show? Prosecutor needs to show that the juvenile has committed acts that would render them to be a danger in the community, to allow them to continue to be outside the walls of a detention center will be dangerous to the community. Also in instances where you may have a juvenile who has a history of being a flight risk, where they have missed multiple court appearances in the past, they have not reported to let's say a probation officer previously and have violated probation terms. So you really have to look at it on a case-by-case basis depending on what facts are being brought before the judge at the detention hearing. But effectively, if the prosecution meets their burden at the detention hearing, the court will schedule another detention hearing and will continue to do this within a span of 14 to 21 days, because there's a presumption in the state that juveniles are not to be detained, especially pre-trial while the matter is going on, because the emphasis should be on getting the juvenile the help they need outside the walls of not a courthouse, but of a prisoner detention center.
So if there is this detention hearing, the witness at the detention hearing for the state would be the arresting officer, typically?
The arresting officer would likely be the case, and any documentary evidence could also be introduced at that time. And then, again, it's probable cause standard, so we're not talking about guilty beyond a reasonable doubt.
More likely than not.
More likely than not, right. So it's a much lower burden for the prosecution to meet.
At these hearings, is defense counsel able to cross-examine or the officer to determine whether or not the state has established probable cause, or more likely than not that this juvenile has committed the alleged act?
The defense would have the opportunity to do that based on the notions of due process, basically in our nation, in terms of being able to have a fair opportunity to cross-examine, to impeach, and to obtain any information necessary in order to establish that there's no reason to have a continuing, ongoing detention of the juvenile, and that would be harmful.
And if the court, so it's not a question of guilt or innocence at these proceedings, or culpability or an adjudication of delinquency. It's a question of whether or not the state has the sufficient evidence to hold the child and the juvenile in detention. Is that accurate?
That's accurate, Bob.
And if not, does that mean the charges go away, or that the child is able to go home and be with his parents and subject to certain supervisory responsibilities of the parent and maybe the court system itself?
That's the latter would be correct. Is that the court would release the juvenile with conditions and stipulations for the release pending another court hearing. The charges do not get dismissed; they continue, and so the juvenile will be awaiting their next court hearing date to go before and respond to the charges. One other point I wanted to mention is, unlike when we're dealing with a criminal matter for adults in the Superior Court, in juvenile law, there is no bail. There's no bail that goes on.
We don't have bail any longer in the state anyway, but go ahead.
Right.
Yeah, no bail.
In juvenile cases, there is, again, the presumption that the juvenile should be seeking any type of services, whether that's educational programs, vocational training, mental health, substance abuse counseling services, in order to help them through the process. Because the actual benefits that they're going to be receiving are going to be greater outside than they are inside a detention center or a residential care home.
Good. So, and those hearings that once the juvenile, assuming, is released to the custody of his parents, the second hearing or the actual adjudicatory process, is that within 14 days, or is that just in accordance with the court calendar as expeditiously as possible?
If the child is detained, then typically the adjudicatory hearing is going to happen within about 30 days of when the complaint is filed. So it's typically within a very short period of time. Discovery in those types of cases, which means documentation that's provided by the prosecution to the defense, is typically done within a few days after the juvenile complaint is filed. So there is a very short time frame. When it comes to juveniles who are awaiting a hearing date, who are not detained, that time frame can last a little bit longer, but understand there are speedy trial laws that have been enacted within the last few years, so there is also an emphasis of getting these cases disposed of within a relatively short amount of time, within about 180 days at the latest.
At these hearings, are charges, probable cause hearings, are they ever dismissed? I mean, and that the state really does not meet its burden, or is that very rare?
That can happen in some cases. I think especially where you're dealing with conflicting information that's brought before a court, where there's question as to whether or not that a prosecutor is going to be able to meet their burden at an adjudicatory hearing, because at an adjudicatory hearing, the burden is a lot higher. It's guilty beyond a reasonable doubt. It's not preponderance of the evidence or showing a probable cause.
And what happens when there are multiple juveniles involved in, let's use an example, a joyride? We used to call them joyriding in my day. I don't want to call it a carjacking, but where a number of juveniles steals a Maserati and they joyride and they're caught. And now we have 3 or 4 juveniles together. How does that kind of proceeding work?
In those type of proceedings, you have a couple different issues at play. One, you have whether or not all 4 of those juvenile defendants are going to need to have separate counsel. Some of it is going to depend on whether the facts or the alleged incident is going to implicate all 4, and whether or not one attorney can effectively represent all 4. In most cases, in abundance of caution, the courts would require those defendants to have separate attorneys representing, separate counsel.
And are those individual defendants or juveniles those matters heard together? The defendants, the case is consolidated to hear all together in the interest of, of expedition.
Absolutely. I think there is a question about judicial efficiency, but when you're also talking about a juvenile's liberty, you've got to be cautious about, prejudice happening in a trial where there may be evidence that is revealed that implicates multiple juveniles in a case, where you may have to have a situation where a case is bifurcated. So you may be trying 1 or 2 of the juveniles in one proceeding and then 1 or 2 in another proceeding. There's also a case where 1 or 2 of those juveniles may plead their case out with the prosecution, in which case 1 or 2 of those juveniles may be a cooperating witness in a trial, and they may be the star witness testifying against 1 or 2 of those juveniles.
True. And similarly in the Superior Court in the criminal case, so there's a lot of parallels, and one of the reasons why counsel is necessary. Now, let's see. Are there criteria which a court relies upon as to whether a juvenile will be detained during their court case? I think you've answered that question, and we talked about what happens after the initial appearance if the child remains in custody. Anything you want to add in that? What happens after the initial appearance? when the child now is in custody? We have 3 minutes. I can't believe.
Oh, wow. The child is going to continue to go before the court in a relatively short time frame, usually within every 14 to 21 days. And so the judge is going to continue to hear evidence from both sides as to why that juvenile should still be detained.
Okay. Now, another interesting point is, is that what if the juvenile is released from detention? Let's assume that. Or is never detained, and the parent or guardian refuses to accept custody?
If they refuse to accept custody, then in those cases, the officer would have to make a decision as to, is there a temporary placement or shelter care for the child, until a determination can then be made by the court system as to where the child is going to spend time. In cases where the juvenile is actually sentenced and the case isn't dismissed, they may not go to a juvenile detention center. They may go to a residential care community in which they're given certain outpatient services in order to help rehabilitate them.
Now, one of the topics that we discussed briefly, or points in our preparation for today, was the issue of waiving up. Firstly, what is the definition of waiving up? And, briefly, juvenile is charged as an adult. Talk about that and what the consequences are and the seriousness of that when that happens.
The county prosecutor has the right to bring an application to waive the juvenile up to be tried as an adult in certain instances. In situations where a child is 15 or older at the time the alleged delinquency is committed, and there is a certain criteria in terms of offenses. We're talking about the most egregious serious offenses, anywhere from homicide to sexual assault to carjacking to kidnapping. It is a laundry list of offenses. They would have to file a formal application with the court. The defense would then have the opportunity to respond to it, and a determination would be made by the judge after that point.
I know you talk about sentencing differences. A juvenile is in juvenile court accused and then convicted or adjudicated a delinquent for carjacking. Serious offense. Penalty versus the penalty in Superior Court Law Division if he were waived up.
The difference is very stark. If a juvenile is tried as an adult and is convicted of a first-degree offense, we're talking about 10 to 20 years New Jersey State Prison. We're talking about an offense that is under the No Early Release Act, which means they have to spend 85% of their time in jail. If it's under a juvenile offense, then it's up to 4 years. It's a major difference.
Major difference. And I don't think we have much time left, but I think you've touched many of the topics that are subjects that we need to know. And any final word of caution or to impart upon our audience what should be done in a juvenile delinquency proceeding?
I would say to the parents out there who have young children, it's important that they take an active role in the child's development, because you don't want them to stray off course. You don't want to have to go through this process, and it's emotionally difficult for all involved. So it would be really a PSA to the parents out there to look after their children.
Very good, and I guess that's the moral here: look after your children.
Absolutely, Bob.
Well, thank you, John. I'm getting the signal that we are wrapped up, and I thank you so much for being a guest on Law on the Line.
It's been an absolute pleasure and an honor to speak with you.
Well, thank you. And we